July the 16th, and now we know what the George Zimmerman jury was thinking.
What do you say to people who are demanding vengeance?
You know, it's nothing I can tell them, but it's something that I can do. I can pray for them.
The Martin family was very clear. The best way to honor their son is in a nonviolent manner.
He was a calm, chill, loving person.
George Zimmerman is a man whose heart was in the right place.
At some point, Trayvon became aware of the gun and was backing up, and George Zimmerman shot him.
Spanish, white, Asian, if they came in the same situation where Trayvon was, I think George would have reacted the exact same way.
It was racial, let's be honest, racial.
Trayvon Martin had the civil right to go home.
The verdict isn't what they wanted, so now they're moving the goalposts again and calling on the Department of Justice.
We pray for Trayvon Martin.
The Justice Department shares your concern. I share your concern.
The first 48 hours since George Zimmerman was found not guilty in the shooting death of Trayvon Martin, and the nation has been plunged into a difficult but inescapable conversation about racial profiling, guns and self-defense. And in less than 30 minutes, the Attorney General himself, Eric Holder, will speak at the annual NAACP convention taking place right now in Orlando, Florida. More on that just ahead. But we are now getting some insights into why and how the jury decided to acquit George Zimmerman, with one juror, known only as B37, saying in a CNN interview that 3 of the 6-person panel originally wanted a conviction. Ultimately, however, she says they came to rest on what they understood the law allowed.
Because of the heat of the moment and the stand your ground. And he had a right to defend himself. If he felt threatened that his life was going to be taken away from him or he was going to have bodily harm, he had a right. That's how we read the law. That's how we got to the point of everybody being not guilty.
One of the key prosecution witnesses, Rachel Gentile, has also given an interview to CNN, chiding George Zimmerman for failing to take the stand, and also saying that she believes race was absolutely a factor.
It was racial, let's be honest, racial. Trayvon was white and he had a hoodie on, would that happen?
Civil rights leaders, including the Reverend Al Sharpton, president of the National Action Network, and our MSNBC colleague, have called for public gatherings in 100 cities this coming Saturday, even as one protest turned violent. In Los Angeles last night, a fringe group broke away from a peaceful demonstration and began breaking store windows and destroying property. However, the vast majority of protests have been peaceful, even as this delicate national conversation continues. For more now, I'm joined by Kerry Sanders from Sanford, Florida, who is with the city's mayor, Jeff Triplett. Kerry.
Well, Martin, we're here with the mayor because this is, in many ways, not only the epicenter of events, but it is the epicenter of calm. We have seen the events in Los Angeles and Oakland, in Milwaukee, where protesters have gotten a little out of hand, although it's just a small group. Nonetheless, here, things are calm. So I guess I'm curious, as you look forward to this Saturday, marches in 100 cities, organized by Reverend Al Sharpton. You've seen a lot of people show up here before. Sure. What are your concerns and how prepared are you?
I think we're continuing with our preparedness plan that we put into place for the trial. You know, last year, as we speak, a lot of people came to our town. It was absolutely peaceful. There were no arrests. There was no violence whatsoever. Our expectation is that's going to be the same. We've always said from day one, people have the right to demonstrate, to protest, to get their word out, but they have to do it peacefully. And I think the citizens of Sanford, luckily being in the epicenter, we've been having this discussion for 16, 17 months about being calm, calm, about being peaceful, about how do we grow from here and how do we move on with these discussions.
It's a good question. Have you found the answer? How do you grow from here?
I think we've gotten closer than we've ever been in the city of Sanford, and as a nation as a whole. As you know, I was asked a little bit earlier today, as the true division of race between, you know, the one side and the other, and there's a lot of people that were hurting originally on. I think what this has done is allowed them to talk to a lot of people. We've done a lot of listening. When you hold something in for that many years, things that happened 50, 60 years in our city, you know, it becomes a chapter in the book. This is another chapter in the book, and we're going to move on from this. And I think it's truly having people sit down at the same table together, having respect for the concerns, and not saying I can walk in your shoes, but I can walk next to you.
Thank you very much, Mayor. It is an undertaking that you have taken the challenge here, but it is also a difficult challenge because, as the mayor points out, this is not a new issue. It's just newly risen to the surface. Martin?
Kerry, a quick question, if I may, to you. We understand that Mr. Zimmerman will be getting the gun that he used to kill Trayvon Martin back. Do we know if it's already been returned? And if not, who has it?
You know, that is such a good question because we have been in touch with the court. The court no longer has the Caltech 9mm pistol. We've been in touch with the Florida Department of Law Enforcement. They no longer have custody of that weapon. We have been in touch with the sheriff's office. They no longer have custody of that weapon. And about 30 minutes ago, I called the prosecutor, the special prosecutor, Angela Corey. She answered a phone. She said, you know what, I'm getting in the car with my chief spokesperson. She'll call you right back. TikTok, I haven't gotten that call back. I don't know where that pistol is.
Kerry, thank you for making the inquiries, and Mayor Triplett, thank you to you. For more now, I'm joined in the studio here by MSNBC contributor Joy Reid and defence attorney and former prosecutor Karen DeSoto. Joy, Miss Gintel says race was clearly a part of this, while juror B37 says race was not even discussed in the jury room.
Yeah.
Why was that?
It didn't have to be, because she also said in that interview that of course Trayvon Martin was suspicious. I mean, there he was in his hoodie walking through the neighborhood in the dark and in the rain, ipso facto suspicious. She had such an ingrained sense that George Zimmerman was inherently good and that Trayvon Martin was inherently suspicious. You didn't need to put it on the table with 5 white jurors in the room and one of, you know, we're saying of ambiguous race, but, you know, she was in the minority, so that doesn't even matter. So the point is that there are so many assumptions that these jurors brought to the table that were, I think, expertly exploited by the defense when they showed that picture of Trayvon Martin, you know, with the shirt off, when they had a white woman who lived in the complex say, black teenager broke into my house. They used a lot of subtle cues where you didn't even have to make it plain.
Subtle, Joy.
Subtle maybe to those jurors, put it that way. Not so subtle to the rest of us.
Okay. Karen, one juror thought Zimmerman was guilty of second-degree murder. 2 felt he was guilty of manslaughter.
Right.
And yet 16 hours later, all of them come back with a not guilty.
Right.
Now, was that, do you think, because of the complexity of the legal language in the judge's instructions?
I can tell you this, it's very common in both civil and criminal cases for the jurors to go in the back room and they'll do a straw poll right off the hop to see where they're at after they put in place a foreman. And a lot of the times you will always have 1, 2, 3 people who don't agree. So what do? They do the same thing that the jurors do. Well, there's only 6. It's not like 12. So that's not uncommon. So then they'll start methodically going through the evidence. And you know, I mean, we've heard of a lot of cases where there's always one that's you know, very adamant, and by the end, after 2, 3 days, they're in agreement with the others. All of the psychological things that go into that, and we can't go into, but it happens quite a bit.
Okay. Well, Joy, the juror says both Zimmerman and Trayvon were responsible for the altercation, and both could have walked away. But when asked who she felt was the aggressor, this is what she said. Take a listen.
You believe that Trayvon Martin was the aggressor?
I think the roles changed. I think George got in a little bit too deep, which he shouldn't have been there. But Trayvon decided that he wasn't going to let him scare him and get the one over up on him or something. And I think Trayvon got mad and attacked him.
So who was the perpetrator and who was in the defensive position?
Yeah, you know, and she's basically making it sound as if, you know, sort of George happened upon him. You know, I don't know. I thought it was interesting the extent to which this juror absorbed wholesale every word out of the mouth of George Zimmerman. Even when she was asked, did she think he was not credible in any way? Absolutely not. And whatever he said, she went with that narrative, and she even added sort of more colorfully. She described it as almost as if she was there. So, and this was also the juror, by the way, who said that she thought the protests before the arrest were riots. So I suspect that this juror came into this case ready to acquit and probably had a very strong opinion about that. And there's all sorts of things about groupthink, but clearly the people with the stronger opinion a lot of time will overwhelm those with the contrary opinion.
Karen, in the legal argument, was it not the case that the defence managed to get the jury to think solely about the altercation, and the prosecution failed to get them to think about everything that led up to that?
And if you notice, what she said was at some point it changed, meaning they felt that he was wrong, but then they might have believed that he did turn around and punch them, and then it was a free-for-all. So clearly they were their version, they agreed with the defense with that one. The prosecutor didn't go into that as much as I think we all thought that they should have. And, you know, at the end of the day, the jury instructions and the way that they were worded meant that if that altercation was ongoing and he felt threat and there was a bodily a threat there, that he had a right to defend himself. There was no jury instruction that said, okay, at this point or that point or this point. So clearly, when two people get in a fight, the jurors have to determine who started it, who didn't start it, and what point are they going to start going forward to decide whether there was self-defense.
See, that's then my question, because it leads you to wonder why the prosecution didn't hammer home and try to get into those jury instructions the initial aggressor rule. Because yes, Florida has stand your ground. This was not a stand your ground case.
Correct.
But inside the self-defense statute in Florida is an initial aggressor rule. If she just said that George got into it too deep and then it changed, that means that she maybe agrees that George Zimmerman was the initial aggressor. Well, according to Florida law, the initial aggressor rule withdraws your ability to use stand your ground or self-defense. Why didn't prosecution hammer that? I never even heard them discuss the initial aggressor rule. So it seems that once again, the prosecution failed to put forward a narrative that would give any jurors who did want to convict something to stand on, some ground to stand on.
I think that we had taught, Joy and I throughout the trial had said that there was no cohesive theory with the prosecution. There were just assumptions and question marks, and at the end, there were more questions than there were answered. And so it just wasn't cohesive. There was no theory. They always tell you from day one in law school, have a theory and follow it all the way through to the end.